Hey, what's up everybody? This is Mike Riley. So my last video is about when the police can search your vehicle without a warrant. That inevitably brings up the topic of probable cause. As I discussed in that video, one of the exceptions to the warrant requirement is that the police are allowed to search your vehicle without a warrant when they have probable cause to believe that a crime has been committed or is being committed. So I got a lot of questions in the comments. Well, what does probable cause mean? What is it supposed to mean in the Fourth Amendment of the Constitution? How does the United States Supreme Court define it, and how could we really understand this concept and use it to our advantage when interacting with the police? So today I'm going to try and explain what probable cause means, why it's significant, when it comes up in court, and how you could be a better informed citizen. So again, when we're talking about probable cause and we're talking about search issues, it all comes back to the Fourth Amendment. And just so we're all on the same page, I'm going to read the Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So there it is. Probable cause is mentioned directly in the Fourth Amendment, but then what does it mean? What does probable cause mean? What do the police need to be able to do a search? What do the police need to be able to arrest you without a warrant? So in order to understand what is meant by the probable cause requirements set forth in the Fourth Amendment, we have to look to the United States Supreme Court. The Supreme Court is responsible for ruling on issues of constitutional magnitude, and the Supreme Court is there to interpret the Constitution and clarify what is meant. And you've heard this before, but it's a living, breathing document. Not everything is certain. There's always wiggle room, and that's where lawyers come in, and that's why we argue about these things. So in 1949, in the case of Brinegar versus the United States Supreme Court set out to define what is meant by the probable cause requirement found in the Fourth Amendment of the United States Constitution. In Brinegar, the Supreme Court defined probable cause as where the facts and the circumstances within the officer's knowledge and of which they have reasonably trustworthy information are sufficient in themselves to warrant a belief by a man of reasonable caution that a crime is being committed. Now, you might think that this is raising more questions than it is providing answers. What is reasonably trustworthy information? What is a man of reasonable caution? So there's still room to argue, and lawyers love this stuff. We get in and we get to argue what is meant and what is not meant by this language. There is no specific test set forward by the Supreme Court to determine when there is probable cause and when there is not. It is judged by the totality of the circumstances. That means that a court is going to look at all the information, all the facts available to an officer when deciding if that officer had probable cause to either arrest somebody, seize something, or search someone. So what type of things do the police rely upon to make a showing of probable cause? Well, first and foremost, they could rely upon their own observations and experiences. So what did the police see? Did they see somebody committing a crime? Did they see something that gave them reason to believe that something was happening that was illegal? We see this a lot in cases that involve undercover officers. So you might have a police officer who's dressed in plain clothes, trying to buy drugs, trying to buy guns, trying to catch somebody in the act of committing a crime. A police officer who is acting as an undercover agent can then document what they experienced, what they observed in an affidavit, and use that to support a finding of probable cause. Police officers can also rely on the statements of other people, other witnesses, people who give them tips, different kinds of information. Now, I'm not going to get in the weeds of this, but not all tips are created equally. Not all witnesses are the same. We have to consider things like, is this person involved in criminal activity themselves? Is this perhaps a rival drug dealer? Is there bias? I see a lot of cases that have confidential informants, people that the police are not disclosing the identity of this person, but they're saying, hey, listen, it's basically a snitch. We've worked with this person before. They've given us information. It's reliable. I think defense attorneys need to push on this issue, question who that person is, because it matters. If this is some crackhead with a history of lying, I don't think that's the same as a concerned citizen who happens to see something or say something. And a lot of times I think that the police try and hide the identities of the confidential informants, not just to protect the safety of those individuals, but because these individuals often have significant credibility issues. Courts like to see corroboration of information put forward by confidential informants. Can the police corroborate some sort of criminal activity, some sort of criminal behavior indicated by the confidential informant? If the police can verify or corroborate that information, a court would be much more likely to agree that there was probable cause. Another type of evidence that the police use to support a finding of probable cause would be any admissions. We've all heard it. It's in the Miranda warnings. Anything you say can and will be used against you in court. This includes in affidavits when the police are seeking a finding of probable cause. Any statement that you make can be used against you. It doesn't have to be made to a police officer. Let's say you're sitting at a bar and you turn to the guy next to me and say, "Hey, you want to know something cool? I robbed a jewelry store last Thursday." That statement constitutes an admission and it could be used against you. It could be used by the police in an affidavit seeking a finding of probable cause. Sometimes I also see the police talking about someone's general reputation or the reputation of a particular area. I've seen countless affidavits where the police talk about a high crime neighborhood, that so-and-so lives in this neighborhood that is known for drug trafficking, guns, and that should help support a finding of probable cause. Again, here, the courts are looking at the totality of the circumstances. So the police are going to throw in any information that they believe will help support their argument that there's probable cause to believe a crime was being committed. The police can also rely on forensic evidence if there's DNA hits, fingerprints, things like that. They can use the data from cell phone tower triangulation. They can use this technology to put somebody reasonably close to a crime scene at a particular time. Again, all of the information the police have, they're going to try and throw in the affidavit in support of probable cause to try and get a judge to sign it. So we've been talking about probable cause in the context of search warrants because the police need to convince a judge that there's probable cause to get a judge to sign a search warrant. But that's not the only time probable cause comes up. The police need probable cause to arrest somebody without a warrant. Obviously, there are what we call on-site arrests. These are not situations where the police submit an arrest warrant in advance. These are situations where the police respond to a scene and make an arrest. They're making an arrest based on their observations on the scene, based on the information that they learn, talking to the witnesses. They can make an arrest based on probable cause. If you are arrested without a warrant, you'll have an opportunity to challenge this probable cause finding in court. If a judge decides that there's not probable cause to support an arrest, the case isn't automatically dismissed, but the court can't hold you on bond. If there's not a finding of probable cause, you have to be released. Probable cause also comes up with some serious felony cases where you have a right to a hearing in probable cause to challenge the state's evidence, and the government in this situation would have to make a showing of probable cause to justify the continued prosecution of someone for any particular crime. So the police need probable cause to get an arrest warrant. The police need probable cause to arrest you without a warrant. Like we talked about in our other video about motor vehicle searches, the police can search without a warrant if they have probable cause to believe that a crime was committed. And lastly, the police need probable cause before they're going to seize any piece of evidence. The police don't just get to run up to you in a motor vehicle stop and start grabbing things out of your car. But let's say that you're pulled over by the police and there's a bloody knife sitting on your passenger seat. There's just been a report of a stabbing. A police officer in that situation would probably be justified in seizing the bloody knife because he or she has probable cause to believe that it's related to this stabbing. It is worth noting that probable cause is a low standard. We deal with several standards in the legal system, and probable cause is among the lowest. So probable cause is what the police need to arrest you without a warrant, to conduct a warrantless search, to get a search warrant, to seize evidence. It's not enough to convict somebody. If an officer has probable cause to believe that a crime has been committed, he or she can arrest somebody, but that does not mean that that person is guilty of a crime. That person still enjoys the presumption of innocence up until that person either pleads guilty or is found guilty by a judge or a jury. You only become convicted of a crime at trial if the government provides proof beyond a reasonable doubt. Now, this is the highest standard in the American criminal justice system, and it is quite a bit different from probable probable cause. So this is why we see situations where the police may be justified in arresting somebody. However, there is not sufficient evidence to support a finding of proof beyond a reasonable doubt. So even though that person was arrested, they later may be acquitted of the crime. Just because there's probable cause does not mean that there's proof beyond a reasonable doubt. And lastly, I just want to talk about what a reasonable suspicion is. So just because the police don't have probable cause to believe that a crime has been committed doesn't mean they cannot still stop you, maybe even frisk you, if they have what's called a reasonable suspicion to believe that a crime has occurred. So this is a lower standard than probable cause. Now, if police only have a reasonable suspicion, they cannot search you. They cannot arrest you, but they can stop you and inquire further. And if during that inquiry they gain other information that gives them probable cause, they then can search you, they then can arrest you. So the best example of this that I could think of is somebody who's charged with driving under the influence. Let's say the police observe a vehicle on the highway. Let's say that this vehicle is swerving, that it's not staying in its lane. In this situation, the police probably don't have probable cause to believe that a crime is being committed, but they might have a reasonable suspicion to believe that this person operating this car might be operating the vehicle under the influence of alcohol. In this situation, the police would be justified in stopping the person and pulling them over and investigating further. If they pull the person over and the classic odor of alcohol emanating from the vehicle, red glossy eyes, slurred speech, that would tip the balance. They then would have probable cause and can go forward with making an arrest. So just because there isn't probable cause does not mean the police cannot stop you and inquire further. So what do you think? Does this make more sense? Do you understand this concept of probable cause? Again, it's a fact-based inquiry. It's based on the totality of the circumstances. We look at all the information available and ask ourselves, does this give rise to probable cause? Thank you so much for watching. I appreciate all the comments, the likes. If there's anything else you'd like to hear me talk about, please let me know. Thank you so much.